Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On May 26th, the parties in Goncalves et al. Versus Washington State University submitted the joint status report and discovery plan is on our YouTube channel's community page for the 27th of May. We're going to go through half this time. Page 1 says, pursuant to the court's April 14th order, and then citing to Federal Civ Pro 26F and also Local Rule 26F, the parties conducted a conference, first on April 20th, with a follow-up conference on May 7th and a second follow-up conference on May 26th, and then hereby together submit this joint status report and discovery plan. 1. A statement of the nature and the complexity of the case is stated here, and it states in relevant part under Section A, page 1, the civil action arises out of the unalivings of 4 University of Idaho students, November 13th, 2022, by Brian Koberger, and at the time of the unalivings, Koberger was a graduate student and a teaching assistant in Washington State University's Criminal Justice and Criminology Department. The last line of page 1 now has the plaintiff's version here, their theory of the case. This is not joint. It says here, plaintiffs allege that Koberger engaged in a pattern of threatening, and then continuing on to the next page, and predatory behavior that was well known to WSU, but the university failed to take appropriate action and further committed affirmative negligent acts that caused or contributed to the unalivings of the students. And then it states that plaintiffs are the personal representatives of the estates of the students and assert causes of action for wrongful unaliving and for violation of Title IX of the Education Amendments of 1972 for negligence, gross negligence, and outrage. Then in paragraph B on page 2, the complexity of this case arises from the volume of evidence and witnesses, as well as the standards of care applicable to an institution of higher education. And then citing to Koberger's threatening, predatory behavior was witnessed by dozens of WSU faculty, staff, students, and reported to others at WSU. Koberger also had a history of inappropriate behavior prior to his employment at WSU, and then after the unalivings, law enforcement conducted an extensive investigation and ultimately interviewed a significant number of witnesses and have made publicly available thousands of pages of investigatory files. And then it continues on to state that to date, the plaintiffs have identified nearly 90 fact witnesses with information that may be used to support their claims in this case. Additional complexity arises from the fact that these events occurred in the context of an institution of higher learning. And this paragraph goes on to assert that according to plaintiffs, that WSU, as an educational program that receives federal funding from the federal government associated with Title IX, is required to comply with Title IX. And they're alleging here, as they alleged in the complaint, that WSU failed to do so and that there has been damages suffered. WSU, of course, in the answer and affirmative defenses, have denied any wrongdoing. They have denied that they are liable for anything. As a matter of fact, they have pointed in affirmative defense number 1 to other possible people or entities that would be responsible to the plaintiffs' damages, if any, here. And this leads into the next paragraph 2. Proposed deadlines for joining additional parties is coming up very quickly, June 30th, 2026. Next paragraph 3, the parties do not consent to the magistrate Michelle L. Peterson's jurisdiction here. They want the district court to oversee the entire case, including trial and entry of final judgment. And then they go into paragraph 4, the discovery plan here. The parties do not anticipate promptly settling this case. The plaintiffs do intend to conduct discovery in a prompt and efficient manner so that the matter may be resolved by a jury at trial. So we see here the plaintiffs are intent of having this dispute entertained by that future jury. The parties don't plan to engage in some form of alternative dispute resolution to try to see if there's a way outside of court to resolve their differences. And then after appropriate discovery, however, has been conducted, the parties might be willing to revisit the same. We're going to, at this point, stop here. Please stay tuned to the Indie Zone, where we will pick up with further discussion of this joint scheduling report. Thank you for joining us here today.